Okay, so here we go.
Grand juror number 2, who again, and you all know this, has joined in with the Glogauer Law team to be represented as it relates to this whole unfolding situation with trying to, at least in attempting to unsilence the grand jurors through these.
What does constitutional republic have to do with left and right? Goddamn right-wingers are stupid.
And I'd like to bring up Attorney Kevin Glogauer to go over everything that's occurred in the last several hours as it relates to Judge Annie O'Connell's order. Kevin.
Thank you, Chris. Good afternoon, everybody. First and foremost, we'll let you all know that our office has already spoken with both anonymous grand juror number 1 and number 2, who are very pleased to report that the judge ruled in favor of disclosure, in favor of truth and transparency, and in the interest of public trust. There is a statement that's been released in writing that you all can refer to, and I will answer any questions related to that. But specifically, we've got the order in hand here from my colleague, Mr. John Britton. I want to acknowledge Eric Weber, who's been an integral part of the team as well, and Matt Farah, who couldn't be with us this afternoon. In the court's order, the court weighed all the law and all the facts in this particular case, and specifically weighed the public interest at issue. And the court issued what is a 9-page, very detailed, very well-written order. And the most relevant part to what we're here for today is where she granted our motion to release the grand jury proceedings to include the unrecorded portions, specifically because Attorney General Daniel Cameron kept making statements.
Now that was part of the contention, was that when they released the grand jury recordings, what Daniel Cameron and his office actually recommended to the jurors is not on those recordings. That was one of the things that they wanted to, because if the grand jury was never given the option of indicting the other cops, then it's clear that there was a cover-up. But Daniel Cameron has used the grand jury as a shield and said, no. They said the other cops didn't need to be indicted, but a grand jury is only they're at the mercy of what the prosecutor presents to them. That's why well over 90% of the civilian cases that go before a grand jury, if you and I go before a grand jury, we're almost certainly going to get indicted. Because a prosecutor is in 100% charge of the proceedings.
Or written permission from those individuals. Our clients at this time, as I stated, are very, very pleased. We as a legal team are very pleased and very proud of them for their courage and their efforts in stepping forward, and we're very proud to work with Game Changers and Chris in trying to help the community gain some understanding here on what really happened during the grand jury proceedings. But at this time, our clients do wish to remain anonymous. We are still assessing their position moving forward, and obviously we will monitor any steps that are taken or actions by the Attorney General's office. That's pretty much it in sum. If people have some questions, I'm more than happy to answer them to the best of my ability. Yes, sir.
A real quick clarification. You said all 12 of them. I was under the impression there was more than 12 people on the grand jury. Is there just 12?
There are 12 grand jurors that deliberate. There are often alternates that are there in case someone becomes ill or is otherwise unable to perform that duty during that time period. But I believe this order would pertain to the 12 that actually deliberated on this particular case.
Given that there's not a stay, we can talk specifics now. So what specifically, because this is something that we haven't been able to get to, what is your grand jurors concerned about with the presentation of the Breonna Taylor?
Here we go.
Specifically, the concerns, I think what you're asking is the way that it was portrayed to the public as to who made what decisions and who agreed with what decisions, quite frankly. I think if you look at the Attorney General's statements, they've walked.
One of the things that came out was that the grand jurors actually asked for more evidence. They asked for more body camera footage, and they were denied. They were told they couldn't see it. That's one of the things that they're wanting to come forward and show the public.
Clients, but only to protect their rights. And when they give me permission to speak for them, I will do that.
Also, I don't believe the grand jurors knew that they obtained the warrant illegally, which, fruit of the poison tree. From the moment they obtained a warrant illegally, every other action is illegal.
I wouldn't think it would take terribly long, but the one thing you have to consider is if there's an appeal at the next level, there's always the...
Also, apparently the jurors weren't told that all 12 witnesses said that the cops didn't identify themselves. They were told about the one of the 12 that changed their story a couple months later. Because that's what this is all hinging on. It was a no-knock raid. They had a warrant for a no-knock raid, but they said they announced themselves. Because if it was a no-knock raid and they didn't announce themselves and Kenneth Walker shot and he didn't know it was cops, he's 100% in the clear. He's just defending his domicile. But if he knew it was the cops and he shot at him, which the 911 call clearly states he did not know the cops were at the door. He thought he was shooting at an intruder, which is 100% in his rights. And right-wing gun nuts should be coming to his defense, but they never do.
their own discussions, and in the event that they wanted to do that, you could certainly ask one of them that question, and they are now entitled to answer that if they so choose.
One of the things mentioned in the written statement is that the grand jurors were not presented with any charges besides the one endangerment charges, because, for whatever reason. Would it be normal in your experience for a prosecutor to present charges that it did not feel could be successfully prosecuted in the court?
That's a good question. It's a very technical question. The actual rule on point is that a prosecutor is not allowed to present any charge that they don't believe is supported by probable cause. It's not exactly the same standard as a successful conviction at trial. However, in this particular case, there were certain statements, again, that were made by the Attorney General that don't really allude to that decision having been made by that office, although it would certainly appear that they made an assessment as to whether or not the law of justification or self-defense was going to prevail at trial. That is not something that we believe, and I think we can comment based on what's been provided in writing, that the grand jurors necessarily agreed with or were even given the opportunity to weigh in on.
So just to clarify, your grand jurors at least believe that there at least should have been some discussion about the possibility of self-defense laws, and there wasn't.
Our grand jurors have stated in our written statement that's been released that those laws were not discussed with the grand jurors. Obviously, as you all know, after having the opportunity to review the 15 hours worth of recordings and going through the PIU files, there's a lot of evidence that was provided to the grand jurors. However, once that evidence is provided, the assessment has to be made as to how it applies to the law. The only opportunity that they were given that we can now ascertain from our client's statement, the recordings and the PIU files, were the wanton endangerments. No other laws were discussed, whether it be particular to a certain offense or a defense to a certain offense.
Can you discuss just generally what your clients might be weighing right now in terms of if and when they would speak out?
There's a lot of things to weigh as to if and when to speak out, and I think that would apply to all of the jurors that were a part of this case. As we've talked about before, there is no way to really figure out what level of public scrutiny they could see, whether it be good or bad. As we noted in our filing and as we've discussed freely before, neither of our grand jurors are in this for any type of acclaim. They're not really seeking that media attention. They wanted to contribute to the truth and transparency of this proceeding.
They want to let the public know what a liar Daniel Cameron
They have
is.
to weigh all of that, their own privacy interests, and then again, as we've discussed, any potential appeal and how that may affect their legal rights.
Always listen to Megan the Stallion. She knows what she's talking about.
Hearings that they'd be open to a written statement as opposed to...
She's savage.
They have a preference for one or the other?
Again, it's moving parts. It's continuing to be assessed. There has been a written statement released on behalf of anonymous grand juror number 1, and there was a brief mention of anonymous grand juror number 2 as well in that statement. And at this time, they will stand on that statement and continue to monitor any developments in the case.
If getting the truth out about what happened in the grand jury proceeding is the ultimate goal here, and doing it quickly, why not have the grand jurors make statements that are detailed now before the Attorney General can file it?
Well, I mean, the ruling just came down a couple of hours ago.
It's a personal decision for the clients, and what was discussed and contemplated was what was put out in writing. I would submit that it covers a lot of ground, although it's pretty brief. I think it is pretty specific to the major points of conversation. And obviously, we're interested to see what and if there's a response from the Attorney General's office, and we'll continue to monitor it.
How unique is it for jurors to speak publicly about a case like this? And also, how might this affect the case going forward?
How might it affect Detective Hankison's case or the case? I'm sorry, I just want to make sure I'm clear on your question.
How might it affect anything moving forward as far as what your clients may say publicly?
Very well. The first part of your question, it is very unique to have jurors speak out. It's not entirely unprecedented over the history of our nation. It has happened before. It's happened in the Commonwealth of Kentucky, I think back in like 78 or 79, on a very publicized case as well. But in the modern age, the nearest comparison is in Ferguson, which has been discussed with this case already in Missouri. But as far as what implications it could have moving forward, very few on this particular case, other than some potential regarding anyone who's not been charged with an offense. Theoretically, it could impact that in some way. But as far as the
That's what we're wanting.
Circuit Court, Commonwealth versus Detective Brett Hankison, that'll move forward unfettered, untethered, with no issues whatsoever based on these statements. The bulk of that has already been put out into the public with the recordings of the grand jury as well as the public integrity file. And it's our understanding, and again, you got to read between some of the lines sometimes from our public officials, but it's our understanding they intend to prosecute that all the way through to its end, and I don't think this will have any direct effect on that whatsoever.
And you said you had a conversation with Grand Juror 1, both of them.
Yes.
Can you tell me how they're feeling right now or what their thoughts are?
They're pleased with the result. And again, the conversation was short. It was informative in nature and gaining their consent to release the written statement and making sure they were okay with the wording and everything that was being put out. But to answer your question as to how they feel good about what they're doing. They're happy with the result. They're still cautious about where they go next, and we discussed that very briefly as well. And our office made sure to let them know that we were very proud of them and impressed by their courage throughout the process thus far.
And just to be clear, you're waiting on Daniel Cameron's response before you let them talk?
We're waiting on a number of things, but that's one of them, yes. Whatever the response is from the Attorney General, or if they were to file an appeal, legally that would actually stay the order. That's our opinion legally. That's what we discuss with our clients. So if they file that appeal, whether it's today, tomorrow, or the next day, we would...
Technically, they already filed that appeal
so we're
on Friday.
You said there are multiple things. What other things might you be waiting on?
I'm sorry?
You said there were multiple things you were considering before allowing your clients to speak, and one of them being the appeal. What are the other things that you're considering right now?
Again, it's mostly their comfort level, whether or not they feel good about putting themselves in this position, talking in front of cameras or microphones, doing interviews, how they feel about their anonymity. Although the order is very thorough and we'll continue to parse through it, there was specific language in there about protecting the anonymity of not only our clients but the remaining jurors. So that's something that we would have to discuss as well. And we respect our media a great deal here in Kentucky and across the country, but someone who's never answered questions that have legal implications, you got to be real careful, especially when there are certain interests that have to remain protected. And there are orders that are active out of the Hankison case that also restrict certain things that can be discussed. So that's, again, we're in the very new period of having this order. So there's a lot of moving parts. We've got to see what, if any, response comes from Frankfurt, but also just generally, how do our clients feel? Are they aware of all the things they can talk about? And then does that make them more or less likely to sit down and talk?
What's his timeline to appeal? Does he have a certain time limit, 30 days, 2 weeks?
Well, generally, yes, about 30 days or so to file it. The order, as we interpret it, is final at this time, so they could appeal it whenever they wanted. We don't know what they're going to do. Obviously, we've not had any discussion with them today or really since the hearing. So,
expect them to try to cover their tracks as much as they can. Any legal wrangling they can resort to, they absolutely will.
I don't have a personal stake in it. We're here to protect our clients' interest, and we feel like that's what we've been doing all along. We respect their decisions regarding what they want to do. So we're just going to continue to monitor and advise them accordingly.
contacted by any other grand jurors besides these two?
Not at this time, no, sir.
Guys good? Thanks.
All right? Thank you all. Appreciate your time.
Let's go.
So it still seems like it's going to be some time before we actually do
Physical one right here. Come on.
get some information. I'm going to take a look at that written order, and we're going to talk about that tonight on the big show.